Welcome to the Daily Synopsis. The Indore bench of the Madhya Pradesh High Court on Monday issued notice to the state government on a public interest litigation seeking to assail the constitutional validity of the MP Bhiksha Vritti Nivaran Adhiniyam, which criminalizes begging. A bench of Justices Vivek Rusia and Amarnath K. Sharwani issued notice to the state and sought a reply from them. The petition has challenged the act and rules made under it for being violative of the right to freedom of speech and expression and the right to equality and also the right to live with utmost dignity guaranteed in the Indian Constitution. The petitioner contended that the law follows a vicious colonial logic by seeking to remove beggars from public spaces lest they embarrass the state. A petition has been filed before the Supreme Court challenging the Karnataka High Court's hijab judgment, which effectively held that hijab is not an essential religious practice of Islam and upheld the power given to colleges to ban the wearing of hijab on college campuses. The plea was moved by one Sajida Begum, who had also moved an impleadment application before the High Court. Begum contended that despite pressing the application and urging the High Court to hear the applicant's interveners, the court did not implead them and also did not allow them to urge their arguments and submissions, thereby violating the principle of orality. It was also submitted that teenage girls covering themselves modestly while going to receive education pose no threat to public order. A Delhi court has rejected the bail plea of Gulfisha Fatma and Tasleem Ahmed in an Unlawful Activities Prevention Act case in connection with the Delhi riots that occurred in February 2020. Additional Sessions Judge Amitabh Rawat rejected Gulfisha's plea, noting that there were reasonable grounds to believe that the accusations were prima facie true. One of the grounds for seeking bail was parity with the bail granted by the Delhi High Court in the case of Pinjra Tod activists Devangna Kalita and Natasha Narwal. The court, however, rejected that argument since the effect of the Delhi High Court order had been stayed by the Supreme Court. The Supreme Court on Wednesday held that a daughter is not entitled to any amount from her father for her education or for her marriage if she does not want to maintain any relationship with him. The bench of Justices Sanjay Kishan Kaul and M.M. Sundaresh said that in the instant case, the daughter was 20 years old and free to choose her own path, but since she did not want to maintain a relationship with her father, she was not entitled to ask him for money for education. The Kerala High Court on Thursday issued a slew of directions with regard to the requirement of setting up ICCs or internal complaints committees in production units and organizations in the film industry and political parties. A division bench of Chief Justice S. Mani Kumar and Justice Shaji P. Chali said that apart from production houses which employ actors, even organizations that deal with the film industry otherwise will have to set up ICCs. Furthermore, the ICC will have to be maintained if they are engaging 10 workers or more for managing the office establishment, and also if women workers are employed for wages. However, political parties which do not have an employer-employee relationship with its members and are not engaging in any enterprise or establishment which is in the nature of a workplace need not maintain the requirement of establishing an ICC.
Subscribe to our YouTube channel and click the bell icon.